So I'm just going to play a bit of this video from Verbs, and this is the quite serious matter to do with the council tax fraud, and it's actually summonses that were issued, and they're basically saying that it was impossible for them to process that number of summonses, and they were trying to stop people out of turning up so they wouldn't have to see everyone because there would have been too many people there for them to do it. There are a few things I want to raise in this matter. I think this guy might actually have studied Justices of the Peace, because he's actually calling himself Rob Peace Officer, and his colleague Blakely, and he's wearing that he's wearing a shirt for the laugh with sort of looks like a police badge, but it's not, with a yellow on it. But I'll go into the matter of the Justices of the Peace in a minute. But I'll just play a bit of this.
Unredacted that information by mistake, but they also sent accompanying letters that I don't believe I should have been granted access to either, which showed that the magistrates in Portsmouth did not sign off the summonses that the council were sending until the 21st of June, which eliminated the summonses as such as fraudulent and not valid. And when we delved into the matter that a little bit further, we also found that the magistrates and judges within the Portsmouth Magistrates Court were seeing up to 6,000 summonses that were summoned by the council in under 3 hours.
So hang on a minute, you're saying that a magistrate's court is seeing a vast number of people. I mean, how is that possible?
It's not possible, and that's the whole point and the reason why we're here today. Because when you are summoned by Portsmouth City Council, on the paperwork it clearly states at the bottom of the same summons, which is not issued by the magistrate's court, that you do not have to attend court. So we found that particularly odd and strange, so we looked into it. And when we attended court on the 12th of July of 2023, members of the council were there talking people out of attending court, even though they had been summoned.
This is so hang on, I'm just going to stop you there. So firstly, they've been summoned not by the court.
Yeah.
They've been summoned by the council, who do not have the right to do that.
Yeah, that's 100% accurate, and we can prove it, every word that we're saying here today.
And so on the summons, it says you're summoned, which most people would assume that means you have to go.
Yeah.
And then at the bottom, it's sort of confusing the issue, because it says you do not have to attend.
Yeah, and when you phone the City Council help desk to clarify the matter, they further confirm by their answering service that if summoned, you do not have to attend.
So presumably then, people thought, well, I'm busy, I don't need to attend, so I won't attend. And what happens then if they don't attend?
So on the day that we found we attended, and the council tried to talk us out of attending, and they were quite successful on that day, because of the 13 people or so that did attend, only 3 remained.
So what, out of 6,000 residents, only 3 actually attended?
No, there was 13 there on the day, and the council talked 10 of the 13 out to leaving the premises or leaving the court before the court was actually heard.
That's incredible.
So actually, it was at a court, but there were members of the council there. So the council, the opposition. So I've been going about 4 minutes now. I've probably played a bit. I've used quite a long section of Verbs there, and I don't really want to start triggering all his copyright bells and whistles on his channel. But I actually want, this is like a message to him, it's for communication purposes. So I have actually seen this video before, but I'm coming back to it now. So they were basically there was a too great a number of cases to process than what could actually possibly have realistically been done. That's what they're saying, and they tried to basically get people to go away. You know, that's quite funny, because in my court cases, because they're using the right to petition, and I truly believe that it was illegal to be prosecuted, I didn't actually turn up when I was summoned, and they come and grab me, and they come and sent the police to, well, I actually got put in a cell overnight a couple of occasions. I just didn't go. So that's quite interesting. But back to the council tax matter. So the thing is that this actually was at a proper court. But also they were talking about the summons being issued. Now the thing is, I want to draw your attention to this. Hold on a minute. So there's this Local Government Act 1888. I think that this is really, it's a very, very interesting act, right? Because it basically sets out that it creates the county councils, the areas of the county councils. Obviously, in 1973, our council was made into a metropolitan council and they got rid of the county councils. But this is when the county councils were formed. And this is something that Verbs has talked about on his channel and that he should be interested in. The whole fact that they're actually, this whole corporation thing and franchise incorporated, body corporates and franchises. In some of these older acts, they're stating that all these entities that they're creating for the government and local areas are like franchises and corporate, right? Now, the interesting thing about this 1888 Act is that they are giving the chair or the mayor of the council, they're making them justices of the peace. They're giving them justices of the peace powers. So that means that they can issue warrants and orders and make orders, legal orders and things like that. The chair of the council. Now, that's 1888, right? So there were actually more people than that. I think members of the public, if they wanted to be, they can be made into justice. You can volunteer to be a justice of the peace, which is why I think that gentleman in Verbs' video was wearing that yellow badge to signify that. I know that members of the public can use policing powers to investigate things like the Criminal Law Act and so forth, like, citizen's arrest. There's multiple acts with citizen's arrest powers and so forth. But actually make orders like, justice of the peace, send people to prison or issue warrants, search warrants and things like that, which is interesting when you think of the right to petition and the fact that, you can do it, apparently you can't be prosecuted or suffer prosecution or whatever for what you do. When you're getting the public to sign it, it's almost like, they're getting the jury to agree with it in a way. But we'll get into that later, the origins of the jury. There's several acts for that. And this whole part when it comes to addressing the king. And there were other, when we get into the early 1200s and 1300s, after the William the Conqueror, there were other jurisdictions around the country, and as he's conquering parts of England and some parts weren't conquered, there are different authorities and jurisdictions from, obviously left over from, the Anglo-Saxons, and also you've got Danelaw, and over in Ireland, it didn't get conquered. All of Ireland, was still under some of the ancient Celtic places until Elizabeth I period and so forth. So there were some other jurisdictions, and then when it got brought under the sovereign, you addressed grievances to the king and so forth. But I just want to hold on a second. Now look at this. I've opened this act, right? This is the Local Government Act 1888. It kind of makes me think of Back to the Future, and Marty McFly going back to the 1800s, the Western, it might be the American cowboy period, the 1800s. I suppose you've got all the whole Sherlock Holmes kind of like theme with it as well. But I know we're talking about fact now, not fiction. But so look, every council. The county council may also, without prejudice to any power, whether to appoint committees or otherwise, delegate to the justices of the peace, acting in a local justice, and consisting of the following: whole or part of the county in a power to be transferred to the county and so forth, right? Well, there's if you type the word peace, there are 12 occurrences of it in here. perform any judicial or otherwise act as justices or justices of the peace. Quarter sessions. For the purpose of this section, authority means Secretary of State of Board of Trade Government Board. Okay. I'm just trying to find out. Hold on a second. The County Council shall, as respects the business by this Act transferred to them from quarter sessions or the justices out of sessions, be subject to the provisions and limitations in this Act specified, but say before said shall have and be subject to all the powers, duties and liabilities which the quarter sessions or any committee thereof or any justices had or were subject to in respect of business transferred. County Council may also, without prejudice to any other power, appoint committee or otherwise delegate the issues of the peace, act as a local justice or are consistent. So, hold on a minute. So that Act that I opened, it wasn't the original version of the Act. It was like an amended version. So this is the original version, right? Because it's important to know this, right? As respects the chairman of the county council, he shall be called chairman instead of mayor, and shall be by virtue of his office be a justice of the peace for the county. But before acting as such justice, he shall, if not has already done so, take the oaths required by law to be taken by a justice of peace, other than the oath respecting qualification by a state. So the chair of the council in 1888, they made them justices of the peace. They actually made them a judge. So when it comes to issuing any summons or warrants, the council could do it straight from the council if it's the chairman of the council doing it without having the court to come from the court. Or you could be summoned to the court. The council could summon you to the court as a justice of the peace, but the summons didn't have to come from the court. So that's something interesting and important, I think. Although that, I'm not saying that that's got anything to do with the fact that all those people who turned up at court when there were actual judges there didn't have enough time to process all the documents. But I don't. Now, they removed a lot of the justices of the peace powers, which we'll get on to, and they only preserved some of them, city councils and metropolitan councils. They removed some of the justice of the peace powers, a lot of them, and they restricted who actually were justices of the peace. So, but we need, I think that this is important to know this part here, right? So that's really important right there, because that means that the council, the chair of the council has got the powers of a judge, or is effectively a judge in 1888. And I'm quite sure that that also went all the way through till around the 1960s, because there's an act what I want to show you for in the 1960s. I want to type the word franchise. So there's 9 instances of the word franchise in this act. be a body corporate, right? There are two important things I wanted to point out in this act. So here, right, look. So, the clerk of the Gale Sessions, clerk for the peace, if it was joint committee of the councils and 3 ridings division, said committee, blah, blah, blah. Well, it talks about these Gale Sessions and stuff like that in really way far back. Really way far back into the 12 and 13 and 1500s. You'll learn about those Gale Sessions. Now, it says here, look, the councils of the 3 ridings or divisions where the councils of the county and the joint committee shall, for the purposes of the said property debts, liabilities, and for the transaction of the administrative business and execution of their duties under this act, be a body corporate with perpetual succession and a common seal by the name of the county committee, with the prefix of the name of the county, and with power to acquire and hold land for the purposes of their constitution without license in Mortmain, I'm not sure what that word is, Mortmain. Our council at the moment is wanting to sell land off because it hasn't got much money. But it says be a body corporate. So Verbs has talked about this before, the council actually being a corporation. Also the police forces and so forth. Well, I'm not too sure if they still are or not, but this is in 1888. But what I don't like about this is this, right? So the crown, the sovereign, the government, the constitution of the country, this is like the whole thing to do with Canada. You know, you got that Charles Wells on Verbs as well, saying that, you know, Canada, they tried to fine him, but he challenged them in court, and Canada's not a proper constitution because it was started by the HSBC, like an adventure company for the royals, like overseas adventures and, you know, so forth, that ended up turning into Canada. What I don't like about this is this, right? If it's a corporate body, right? If it's a corporation, a corporate body and franchise, like a political party is a franchise, but the party is not the government. The political party is only an organisation, a political party. When those people are trying to get elected into the government, the political party is just a group of people who have certain political affiliations, right? But all those people in that party try to get elected into government to serve in government, right? This exact word that's highlighted in orange here, a body corporate. So, what I don't like about this is that if you've got a corporate body, which is a local council, right? You've got a judge who is the chair of the council, a justice of the peace. So that means that the chair of the council, the chair of a corporate body, is a judge with judge powers. Right? This is in 1888. I'm not saying now, I'm saying 1888. Right? Now, can you imagine now if Mark Zuckerberg was a judge, a justice of the peace? How would you take Facebook to court? Because if you wanted to take Facebook to court to like challenge them over political rights, what if he was a judge? What if Mark Zuckerberg was a judge, a justice of the peace? I make the orders around here, you know. Well, you don't go to a court, we're telling you. But just a minute, where's the jury? Oh, it's my staff, you know. Well, you know, when you're blocked, what happens if Facebook block you? You know, you're trying to collect petition signatures from the public to challenge them, you know, or use another platform. You know, what happens if Elon Musk, you know, in his corporation was a justice of the peace? How can you have Mark Zuckerberg versus Elon Musk in court if they were both justice of the peace of corporations? You couldn't, because they would both be making orders against each other, right? Now, you've got to have the people in here somewhere, or the public at large, because in like in Crown Court cases and so forth, you have the jury, the public decide. But what they're trying to do is say that we don't have any rights to decide anything when it's political matters. You can even have political posts on this website. So if you can see now what happens if Bill Gates was a justice of the peace. Now, the thing is, right, hold on a second. So this is very, very interesting and useful in my research of getting to the bottom of the right to petition, getting to the truth and the history of the right to petition and how it came about, the whole origin of the juries. And I've found a lot of more useful information to fill this in, right? A lot more facts. And I'm a lot more very, very clear now on they had members of the public who were basically looking for criminals, and then they gave evidence to the government and brought them in to get judged by the king. Or sometimes it could be the king, but they didn't actually make the judgments, but they investigated it and brought the evidence, right? And then there were some other jurisdictions until they got rid of them all, and then they brought it all. It had to be brought to the king, grievances and so forth. But you didn't have the right to petition protection at that time, but it was a proper process. So this is almost like the public having policing powers and so forth, which actually what I was looking for. So it kind of, the right to petition, this whole bringing a case to the king or to the government, is intimately tied with kind of like policing, kind of like bringing a criminal case as well to the government or criminal matters. It is sort of all tied in together. Now, this basically just says that they choose like good, trusted people of the realm, and they get made into justices of the peace. That you've got like your sheriffs, your constable, which is like the sheriff of Nottingham. Traditionally you got the sheriff of Nottingham, but then you had these people who were given powers, made into justices of the peace. So you get sworn in. You have to take an oath and get sworn in, and then you can make judgments and so forth. The thing is, there's something when you fast forward to 1688 with the Bill of Rights from 1361, and you actually get when you're bringing a case, you get full immunity and protection from prosecution, and you got the public supporting it and signing it, members of the public. That is, as far as I'm concerned, that's public consent. You're getting the case is being supported and brought on behalf of the public, and the public support what you're doing to pursue that. So this is why I'm saying Extinction Rebellion shouldn't really be prosecuted and face a jury, particularly after the Civil War. There's some power in that. I think what I think is like when you elect an MP, right? It's not this like swearing in a justice of the peace, like we have to take an oath of honesty, to the. It's almost like the king takes an oath. Vobes has been talking about that king taking the oath and so forth. I think Vobes might be ahead of me on some of this, but I think there's some of it as well that they've missed out of it as well. So the thing is that when you have a local councillor, they get elected by public vote. And when you elect a councillor who is going to be a councillor of the Crown in the chamber, and then one of them gets made the chairman, they're not made in by oath. I'm not saying they don't take an oath when they become a councillor, but the power invested in them is from the people. So this power of election, they get so many votes and they're voted in to the council, and same with a minister, like Andrew Bridge, an MP, the power invested in him. It's like we deputise and so forth. The power invested in them by the people, they elect them to serve for a term. The peers get made a peer for lifetime. Now, I am absolutely certain now that those when you got the these people who used to go around like a jury giving evidence, this is like that is like a police investigation. So this is like when you said, you know, the people police the laws or whatever. Now, this is way before you've got the right to petition official immunity of the 1688 bill and the Claim of Right Bill 1689. Now, the thing about it is that it's they make this law where once you're bringing a case to the sovereign officially, you're bringing the grievances or cases to them and not any other person, not any other people of the land or authority. And that made the difference, because that actually then it's setting out a lawful due process to a recognised authority, right? And that changes everything. And then you got the Tumultuous Petitioning Act, when all matters are brought under the King's Bench. But what makes the difference is that 1688 bill, because you absolutely get, when you are bringing the case, you're getting the immunity. And bringing some of these cases, you can do it over criminal matters. Now, the Petitions Committee at Parliament at the moment are trying to reject anything that's to do with like crimes or so forth. But the House of Lords can deal with judicial matters and crimes, and it's part of the basic function of it. And what it is, this Appeal Jurisdiction Act, that's for cases that have already been decided on. The Appeal Jurisdiction Act was for cases that have already been had a hearing, and you want to elevate it higher, not for bringing a case in the first place. And all of this, you could, before they had the jury, they had this like trial by like water, but like used to submerge people in water and all those kind of things, a ordeal, trial by ordeal and so forth, until they got these juries in. And then, but the thing is, you could actually, even back then, if you had to face an ordeal or a jury, they still had this procedure where you could bypass that and you could elevate it straight to the king and ask for a special investigation from the king himself if you've been accused of a crime and you didn't want to actually go through these trials like be dunked in the water. So there's always been this, even in a criminal case, to go to request that matters be taken to the king for a special investigation. And I think that in the right to petition, even that in the 1661 Tumultuous Petitioning Act, this is kind of complicated, really. There's a lot of you need to understand the skeletal basis framework of it. But with that Tumultuous Act 1661, they said that if you get over 20 signatures, it's got to go through, even the petition has got to go through a grand jury or justices and so forth, be looked at and checked. Now, in 1688, they said that you can't be held to any commitments. All prosecution commitments are illegal for petitioning the king. Now, the thing is, if you couldn't be held to any commitments, what about that Tumultuous Petitioning Act, where it says that, if you've got over 20 signatures, it has to be checked? What about being held to that commitment? Well, the thing is, you could petition like the Houses of Commons or the House of Lords. Or you could be petitioning the local council when the local, obviously, the local council, if it's not for a matter of central government, if it's for a petition to a local councillor's authority, then they're going to be looking at it anyway. But what I think that act, and this is something that Karen Bowie sets out in her paper, there's a discrepancy in that Professor Karen Bowie paper, and she writes something that is a mistake in there, but it's kind of like an intentional mistake. Now, the thing is that we've got this confirmation that you can bypass lower court cases or judgments, even before the judgment have been made, and have an investigation by the higher authority, the king, and you've got the right to do that without being held to any of the commitments from. So that's not actually, it's not actually, what it's doing is, it's not like an appeal. It's not like if you go to court and you get found guilty, then you appeal to the Crown Court, and then you get found, they say, no, we still think you're guilty, but then you can appeal to, the Supreme Court, or, the Royal Courts of Justice, or whatever, right? It's not like that. This is like, before you even go to trial or have a hearing. This is like before you even, if you go to a magistrate's court on a charge, then this is not even like going into the magistrate's court and being found guilty and then appealing to a Crown Court. This is like from the square one. From the moment you get this charged or summons, you can go straight for an investigation from the king. And that is actually completely and totally reaffirmed and secured with the right to petition of the whatever subject it is. Now, that means that you aren't to be held to any of those commitments of the 1661 Tumultuous Act. But the thing is, you've got a lot of different matters you could be petitioning about, local council matters, or your MPs in the Commons and Lords. So it appears to me that you've got this direct channel, avenue, which is to jump over and skip over the other jurisdictions and authorities because you want it raised higher. Now, one thing that's interesting about this Justices of the Peace Act is that this is like 1361, so it's like 200 years or 300 years. This is like 300 years after William the Conqueror and the Normans come over. But we've not quite, we're in between sort of, Oliver Cromwell becoming the Lord Protector and ousting the royals. We're exactly in between, the Anglo-Saxons, period, and then this Norman conquest of the French. And we've got, this act is talking about people who basically don't like the royals or don't like the people who, they're still recognised as, the conquering force. And this act, I think this act was originally written in, look, there's some of the original writing here. Ce sont les chambres, this is like in French. That looks like French to me. Les dimanches prochains devant les festes de la conversion des signes pour les tenir pour les imprimer les volumes Saint-Fossé en Chasseur County de la Solène Assignes pour la garde de la prise en Seigneur. So this is almost like, it's like listening to Howard Crowhurst or something. This isn't it, Professor Tom. And tous of Barat and de les pursuer arrêter prendre Chastille selon le trespass en mesprisine and les faire emprisonner et durement punir. So this is in French. That's the original. This act is not necessarily in the form in which it is in effect these be the things which our Lord the King, the prelates, the lords, and the commons have ordained in this present Parliament, holding at Westminster the Sunday next before the feast of the conversion of St. Paul, to be holden and published openly through the realm. I've never heard that at the start of an act before. You're really getting back a bit now with it starting like that. It's talking about that's sounding a lot more like Magna Carta. And I'm quite happy that there's definitely the exact pieces of Magna Carta in that petition of rights. So it's unlikely that Magna Carta is fake. Like one of the guys claimed on one of the Richard Robes videos, claimed that Magna Carta was forged, but I don't think it is, because it's the petition of rights based on it, and I really doubt that they would base exact paragraphs of proper law that we know is actually enacted on it if it would have been false. Who shall be justices of the peace? Their jurisdiction over offenders, rioters, barraters, they may take surely for good behaviour. First, in every county of England shall be assigned for keeping of the peace one lord, and with him 3 or 4 of the most worthy of the county. Well, that's who do they think's worthy? With some learned in the law. Right, so you just have to know the law, basically. And they shall have power to restrain offenders, rioters, and all other barraters, and to pursue, arrest, take and chastise them according their trespass or offence, and to cause them to be imprisoned and duly punished according to the laws and customs of the realm, and according to that which to them shall be seen best, to do at their discretion and good advisement, and to take and arrest all those that they may find by indictment or suspicion, and put them to prison, and to take all of them that be not of good fame. So, well, we'd all be under arrest now unless we're Ant and Dec. Everybody except Ant and Dec's under arrest, unless you're celebrities. This is the thing now. If you're not a celebrity, then you belong in the audience clapping. You can only just move your handcuffs enough to clap. Like we're only meant to be there to applaud these people. It's all about being famous, isn't it? When they shall be found sufficient surety and main prize of their good behaviour towards the king and his people. So who is the king and his people? If there are some people who's not the king and his people. So this is actually the main part that I wanted to draw attention to, right? It's all about being toward good behaviour towards the king and his people. Well, who isn't the king's people? He's saying there are some people, he's claiming that there are people who aren't the king's people. That means that, so does that mean that there are some I thought we were all subjects of His Majesty. We're all subjects of, Great Britain, or all the king's subjects. Apparently some people aren't the king's subjects still. So they're not ruled, if they're not the king's people, then they're not ruled by him. It seems to be that they should be ruled by him according to this. And if they're not, then they're going to be captured and brought good behaviour towards him. This is got rule and conquer written all over it. This is going out and finding. It's actually saying that not everyone is a subject of the king. Not everyone is a subject of the realm, because mainly all the realm's not been conquered, particularly in Ireland. There are many parts of Ireland still under Celtic rule at this point. I think that this is when you've got those clog teachers up. I still think they've got those clog teachers up. This is before you've got the proper church. You've got the separate bell tower and the congregation church in Ireland going on around this time. So I know that they've probably taken over quite a lot of England, but there was a lot of resistance in the north, even after 1066 and so forth. The thing is, the Normans come over and they start doing domesday and surveying and telling everyone the land's not worth as much and so forth. I'm not surprised. No, these aren't the king's people. This is about Norman power, the power of the elite. And, you know, how dare they say, oh, of good fame? Apparently, fame is a virtue. In the 1300s, you know, you got to be famous. Good fame. You know, you see, this is like bringing up the whole kind of like, you know, the outlaws and the whole Robin of the Hood and so forth, isn't it? You know, if you're not famous, then they're not interested. You know, you're not good enough. This is why I don't like celebrities now and people who sell out to the whole kind of like materialistic greed television game show. Even like the bassist from Blur apparently, you know, ends up, you know, from his you know, modest upbringings in Chelmsford, ends up in London. Or I think Damien Albarn's from, you know, Chelmsford. But, you know, the bassist from Blur, Rebecca Brooks from The Sun, knocking around Chipping Norton with, you know, David Cameron, and, you know, conjuring up all the newspaper stories, putting themselves in the newspaper, having a laugh at each other, making themselves famous, you know, Jeremy Clarkson with Boris Johnson popping up on there, you know, and all these, you know, racehorse owners. These, you know, David Cameron, he's like a you know, he's almost like a model of a Norman, isn't he? A Norman conqueror, and now he's been raised up to the ranks of the Lords. Now he's of good fame. Although Tony Blair's not quite of good fame because he had a petition. How can Tony Blair be of good fame when he had like a petition of, you know, 1.5 million people not wanting him to get knighted? Certainly not of good fame. He's been arrested multiple times, citizens arrested for war crimes. Certainly not of good fame. The king and his people. So, who isn't the king's people? You know? And what, you know, if there are other jurisdictions and there were other jurisdictions still in effect, that there were other, because you had Danelaw, remember, and then you've got some of Ireland, which has got its own law. But what's wrong with those laws and so forth? I know that they had trial by ordeal, which is not the nicest thing. But, and then also you've got Pope Innocent as well. You know, I think it was Pope Innocent who completely obliterated trial by ordeal completely. Maybe it was working quite well, trial by ordeal. Maybe there were less people offending, you know, and maybe the king wasn't getting as many fines, you know. After all, if everyone behaves, then, you know, they don't need any justices of the peace. You know, if they had the perfect legal system and everyone was behaving, then surely, you know, they wouldn't need any judges anymore. They'd become obsolete and they wouldn't be making any fines out of people. It seems now in the current, they're making up some ridiculous laws now. You know, you can't say this, you can't say that, you can't look at someone funny if you're in a bus station, don't make them feel uncomfortable. Yet the council's banging houses next to people, destroying their entire lives, ripping the soul out of the village, blocking people's views off, causing a lot more distress than merely feeling uncomfortable in the bus station. Yet that's not a crime. You know, they're allowed to do it. It's kind of ridiculous. So this is joke, this. The king and his people, basically the invaders, the conquerors, written in French, famous people, celebrities, talking about man prize or main prize there, as if almost like capturing Robin Hood is in a cage is almost like capturing some sort of taming a tiger or something. Oh, come on, God, good spoils of the war, yeah? But basically, so they're getting, they're choosing people loyal to the king and learned in the king's laws, basically, to go after the criminals. Now, later on, you've actually got these, this is the jury. They're bringing evidence on people. So that is the origin of the power, really, of the law. The power of investigative policing powers. Now, a justice of the peace, once you're sworn, you take an oath, and the oath will be like the king sort of takes, really, when, this is what Verbs has been talking about, that oath. So to be made a justice of the peace, you take an oath to the realm, to the king, but also to the people, that you're going to be honest and uphold the law and all so forth. But people can become justices of the peace, I think, still now, if you want to. I think some people, he said some people in the... So this is the other thing that I wanted to draw attention to. This is like a Hansard excerpt, and it's a discussion when they're debating or discussing in the House of Lords about the Justices of the Peace Bill, but this is in 1968. So this is well after 1888, when they make the councils into corporate bodies and you have a Justice of the Peace as the chair, right? 1968, this is around, they're having this debate about the Justice of the Peace Bill. This is exactly around the time when they take out that, they remove that provision from the Petition of Right. They take there's two sections out of the Petition of Right, which are the ones that say that you've got to be prosecuted by legal, lawful due process. And which I pointed out, and also defining the jury, that the jury can decide on their own opinion or by the rule of law. And it's the reason that they said that they revoked those two parts of the Petition of Right, which actually is from Magna Carta as well, is it's unnecessary. Well, I say that it's wrong. They say it's not unnecessary when the provision. What does the provision say? Is it anything unique or different or particular? No. What it actually is, this is the entire structure of law which we're doing now. This is what we're doing. This whole framework that we're operating by is lawful, rightful due process. And, you can't be fined or put to prison or anything without being put through lawful due process. So to say that that's unnecessary is like saying that to pick up every act of law that has been written in Parliament and chucking it in the bin and say, I don't need that. Because what that paragraph is every single act condensed into like a marble and put it in your pocket. Well, that's, this is the entire legal system of England. You have to can only be, lawful due... It essentially is lawful due... What is lawful due process? Well, everything that we've made in law now. Everything that exists in law, that is, it's almost like, to screw up that provision in the Petition of Right, which is from Magna Carta, and say, we don't need that anymore, is literally like getting every single act of law that is in Parliament, in the entire, everything that's been put through Parliament into effect, and like scrunching it up into a little ball, a paper ball, and say, no, it's a bag of shit, this is a load of crap, chucking it in the fire. Say, no, you don't need that anymore, it's unnecessary. It's almost like they say, well, it doesn't mean any, or it's not got any meaning to it, it's of no use. Well, of course it's of use. It says that it can only be prosecuted by a lawful due process. So, whoever did that is a simpleton. And the fact is, coming through this 1968 discussion, when you read this, is brilliant. You've got to read this. This is like better, more comedy value than Shakespeare. Some of these lords, right? This is not an act. This is not like theatre. Well, it's not meant to be theatre. It's not intended to be like, Shakespeare or a theatrical play. This is them actually in the House of Lords talking. But what this does is it demonstrates that what they're doing in Commons and in the Lords is charades. It is an act. All this has been recorded and written down in Hansard. and it's like they're playing to it. They go in there and all this actually happened. It was actually spoken. My lords, I beg to move. You know, he's going up basically, right. This member of the House is saying that they want to basically they want to trim down the number of justices of the peace that there are in the country, because a lot of them are unnecessary. Because they've got all those. When I was talking about the 1888 bill and, you know, the chair of the council and so forth, there are different councils. There's like Metropolitan Council, County Council, City Councils, all these different council authorities and so forth. And then there were other people. They had a lot of different people who had these authorities of the justices of the peace, right? But then there were certain members of the public and other people who get sworn in. And what he's saying is, he's going, oh, that they're a rum lot. He's calling them a rum lot, some of them. He's calling them vagabonds. He's calling them mongrels, mixtures. He's saying that, you know, he doesn't think they're legitimate people or not of good integrity. Some of them are a bit, you know, rough at the edges or shabby. But this is the people of England we're talking about when you need a broad spectrum. But so basically, this whole piece here, and it goes on for a long, long time, that he's basically proposing that they trim down the number of justices of peace because they're unnecessary, a lot of them, right? And what we actually end up with today, when we fast forward, is you've only got so many judges and so many people with judicial authority, right? And why it matters is because when you think now of the right to petition and you're taking up special rights, you know, special political rights and privileges to go after criminals or to bring a case to the government, that is a special power, really, the right to petition. When you're getting the public to sign it, to support it, there isn't a power and authority in that, almost like the power invested in an MP by the public or a power invested in a councillor by the public. They're elected by the public and the power invested in them by the public. And this goes back to those early juries who were actually collecting evidence on criminals, but they weren't making the decisions. And it's all under due process of law to the king. But when you actually, it's to an authority, and you've got a legitimate authority form now that it's all been processed through. So what I don't like about it now is that you've got a lot of these, at the moment, you've got all these, like, they're doing so many fines. And what I'll do now is I'm going to draw a circle back to when I started this video with the verbs video, when he's saying that, you know, there were these council tax fines and summonses. There were so many summons that they couldn't possibly process them all. So, and they were talking people out of turning up. So if this monkey in the House of Lords is right, and they've got far too many justices of the peace, they need to trim them down on them. Well, they clearly don't need to trim down on justice of the peace when they're doing the council tax fines, because they ain't got enough of them. There's that many people they're putting through. They're having to tell people not to turn up for summons because they haven't got enough people with judicial power and authority. They haven't got enough justices of the peace, even with the chair of the council sending summons out and warrants, if he can still do it or not. Because there were that many people getting fined and there aren't enough justices of the peace. But in 1968, you wanted to slim down on them. And now we don't even have that many constables, police officers. They were getting loads of community support officers who aren't meant to be proper policemen. But now it turns out that, you know, we can uphold the law and use acts of law like the Criminal Law Act, you know, to pursue criminals and so forth. What I find now is that no one can afford lawyers, no one even can afford solicitors, and the government have got this project for mediators. They're now doing like a fixed fee scheme for mediation where you go to a lawyer or a solicitor, but he's not acting as a lawyer going to court. He's just going to mediate you with the other authority to try and help you come to an agreement, right? For cheaper, like, you know, a couple of £100 or whatever. Now, the problem that we've got is that with Facebook and Mark Zuckerberg, they've got this, well, they claim they haven't got immunity. They're not liable as a third party when they're processing other people's copyright claims and so forth. But that doesn't mean that they can't commit a crime themselves or break the law and a case can't be brought against them. It just means that when they're handling copyright claims from other parties, they're like a middle person. That doesn't mean that the middle person can't break the law or commit fraud or withhold people's rights unlawfully or anything like that. It just means that for things like copyright claims like that, they're just handling it. You know, it doesn't mean to say that they can't fraudulently handle it or be accused of committing fraud or something in their dealings. That's totally different. What's happening now is we're getting a lot of forceful actions by people who aren't a judicial authority, and they're obstructing information and questioning. They won't answer questions. They won't, even companies now won't give information. Tony Blair had this golden era of freedom of information, and there were loads of freedom of information made to the government. And at that time, I can remember around the year 2000, there were loads of people, even though they were saying that companies don't come under freedom of information. I think they do because they've all got a Companies House certificate. But lots of people were making freedom of information requests to companies and businesses, you know, how many widgets do you sell and so forth. And they were answering it. Because of the Tony Blair freedom of information, it was just a popular thing and people believed in it and a lot of companies were responding to it, right? And now it's completely changed. I think it's to do with this whole thing that Tony Blair's been going out whispering in government's ears around the world and getting them to reform and change that whole thing, actually, funnily enough, and, you know, do it this way, do it that way, forceful actions, and the banks as well and so forth, that it... Now companies, private companies and businesses won't tell you anything. They don't even, instead of freedom of information, it's, oh no, we can't disclose anything. You know, they don't actually want to tell you anything. Even if a product's broken and you want to ask a question about it, they don't even want to tell you about the product. You know, or, you know, they don't want you to know anything. I think it's because of the fear of, you know, don't give your details over, all that. You know, they don't want to tell anyone anything anymore. So it's actually Tony Blair. It's almost like he lit this torch of freedom of information like a shining beacon, and then he lit it for a while, and then he dunked it in the water and put it out. And now there is no information. No one can know anything. Now, as far as I'm concerned, these corporate entities have got technology. They've got control. They've got an administrative control of your devices, your information, your posts, your files, your photos, your membership, your ability to communicate. And they are controlling it, and they won't answer any questions, even when you use legal challenge. No one can afford to take them to court, and they're just bossing us, but they're not, they've got no judicial authority, but they're acting like they have. And we're being priced out of real court action, and we're being offered mediation instead. But they've got to agree to mediation. A lot of them could just disagree, like 38 Degrees at the moment, remove my petition unlawfully. We haven't actually got anyone to help us. Now, when they were chewing down on all these justices of the peace, there were a lot more people who had judicial authority to go to make decisions, and a lot more members of the public who weren't affiliated with these corporate entities. They were like liberals or people of reason, people who were interested in fame, people who were interested in greed, in money, people who were interested in the truth, in justice, in modesty, you know. And I think that all this charlatan act through here. Oh, they're a rum lot. I beg to move, Your Honour. They're a rum lot, all these lot, He's basically trying to reckon that, a lot of the general public are a rum lot. And he's basically completely and totally blagging his way through this. At the exact time, 1968, when they ripped the Magna Carta, which was transferred over to the Petition of Right, this rum lot here in the House of Lords don't think that's relevant. They don't think it's unnecessary. What? The Magna Carta, the provision that says that everyone in England can only be, imprisoned or, have their things taken away from them, through a court of law, through due process. Oh, you don't need that part. That's unnecessary. What? It's almost like fucking. It's literally like, Rishi Sunak with his, Rosebank oil rig. It's literally like saying, oh, there's an oil rig there. It's got 4 big posts holding it up. You don't need those 4 posts. Just rip them out. It's like, it's literally like, going to a tree and saying, oh, you don't need these roots, so rip them out. Or it's literally like going to like a building that's been, like when they used to have those buildings in the medieval town centre that were up on posts, like a safe house in the middle of Market Harbour or somewhere like that. And you got it's like a building that's raised up on stilts, like on 4 big stilts. It's almost like, oh, there's a building there raised on 4 stilts. So you don't need them stilts or ripping them out. Ripping 2 of them out and the whole thing falls down. It's literally like going into a church, and saying, oh, there's a Jesus on the cross there. I didn't need that. That's unnecessary. Rip it out. It's literally like going to the Archbishop of Canterbury and saying, oh, what's Jesus doing in your church? Well, what's he got to do with the Christian religion? You don't need Jesus, get rid of him, have Charles instead, There's the entire Christian religion's based on Charles, It's not only unfathomable, irrational, unfathomable, it is absolutely defective. There's a defect. And what we've actually ended up with now are actually corporate entities who don't actually really have any official judicial power, but we can't get access to judicial power. We can't afford lawyers. You can have the small claims court, but the small claims court is really for if they owe you money. But now on most of all these major platforms, it's not about money. It's about the fact that, they're saying we can close your account down for any reason or no reason. So it's about the right. It's about the policy clauses. It's about who's right and who's wrong. It's about what's the truth and what's the lie. It's about what they can and can't do. It's not about owing you money, because on the majority of these platforms, you're not even getting any money. Even now when you're making music, if you make music, you get about, 20p a year or something. It's not about owing you money. It's about who can do what and who can't. It's about the rights. It's about getting the law right. So the small claims court, that's what you want, online court action. Now, one good thing they've got in America is that ccb.gov, which is the copyright claims court in America, which is on legal basis. It's not really about money, it's about rights. But apparently they can only make certain limited decisions, some of these justices and judges could probably make decisions like on Stonehenge Tunnel or on this tree, this Darwin Oak. But the thing is, if chairs of councils are a justice of the peace, like in the 1800s Act, and if they're a body corporate though, and if it's like, for example, Balfour Beatty or Care Traffic or wanting to build a highway through and make X billions of pounds, and the councillor's a Tory councillor and he's got investments and shares in that company, which he's not supposed to have because commissioners of works aren't meant to do that, then, if you vote a political party in and that political party have got control of the council. And if you have the chair of the council as a justice of the peace, it's a corporate entity. And what happens when their traffic department is, like Care Traffic, then it's almost like Care Traffic by being the corporate body of the council. And, if Rishi Sunak's got some shares in Care Traffic, it's like he's got himself a justice of the peace for his own party that's in control of the council and a corporate company. It's almost like the corporate companies have got themselves their own judge. Now, I thought that you took corporate companies to court. I didn't think that they were a court. Now, the problem is, when it comes to these roads and highways at the moment, it seems like they're making their own decisions. Now, the thing is, you've got the right to object. You've got the right to object. But what's the point in objecting to, if the council, right? If the council itself is a judge, but is also a corporate company and entity, and that corporate company and entity like Care has got ministers with shares in it making money, but they're the judge, how are they going to decide in any other decision other than themselves to make money and profits? And out what they want to do. But the thing is, we're electing these councillors, but we don't elect companies and businesses because we don't decide what companies and businesses do. We're meant to decide what the council does. Now, the thing is, when you sign a petition, you're getting the public there to make a decision, really, to override the council. When you have a normal objection, it's on a point of law, like a court case is in a point of law. But when you get multiple persons, they don't need a point of law. They can decide purely on their opinion. We don't want this, like the jury in the Ian Bray case. And that's why it's important for the petition of right and the Magna Carta from lawful judgment of the people, what the people think, which doesn't matter whether it's on a point of law or not. And that's what the council don't want. The council don't want a referendum on Stonehenge Tunnel. The council don't want a referendum on the Darwin Oak because it's us deciding. And this is like in this Hansard thing when the strip is trimming down justices of the peace because he wants it all to be under this more of a corporate body order. And now it turns out that they've all got shares and investments in corporate bodies and now, you can't even afford to go to a court. No one can even get access to justices of the peace because we're being bossed by these big corporate entities who are actually making judgments whether we can be on their platform, even when it's protected speech, constitutionally protected speech, when you're actually trying to get the law made or changed or investigate something under the judicial powers that we've got in law. Now, Mark Zuckerberg isn't a judge. He's not a justice of the peace, and neither is Elon Musk, and neither is Bill Gates. And if he was, then you wouldn't need to take any of them to court because that means they would be a court. It's almost like getting loads of judges in a court together. Who's going to make the decision? Now, at the end of the day, does the jury make the decision or the judge? Now, when we elect councillors to represent us and vote in the council, they're now starting to represent these political parties that are all affiliated with the corporate entities. Now, it's got to a stage where it's the public, the people, against these corporate entities. But if the corporate entities were a judge, how are you going to win? Now, the people actually are the ones who are meant to make the decision, particularly when you're getting a petition and signing signatures. And what the actual truth of the matter is when you get multiple citizens to sign, they are investing their power in that case and in the actions you're bringing. But we're not getting that enforced. What we're getting is big corporate entities who are just actually doing what they want. And that's the problem.